talking about family meetings and conversations and how to have those conversations with your loved ones. Estate planning obviously can be a difficult subject to talk about. Sometimes it's difficult for us to share what our wishes are with our family members. Sometimes it's our family members that don't want to hear it. I have a number of clients who tell me, well, I've tried to talk to my kids, and they just say, I don't want to hear it, Mom. I don't want to hear anything about it. I don't want to think about the time when you're not here, right, or when you're incapacitated. So tonight we're going to share some tips for having those conversations and encourage you all to actually do that as well. Some of the things that we're going to talk about are wishes for adult children and how your plan might be set up and what how you want them to be doing things later on. We're going to talk about minor children. For many of you in here, this might more pertain to your grandchildren, but information you can share with your kids as well to make sure that they have some of these, what we call babysitter instructions in place for their kids. We're going to be talking about what to do for special needs beneficiaries, pets, special and difficult assets, specific distributions, which are very important, healthcare decisions, and memorial instructions as well. Okay. But the way that we like to think of it in our practice is that I want to control my property while I'm alive and well, right? And then I want to plan for me and my loved ones if I become disabled. And then I want to give what I have to whom I want, when I want, the way I want, all while assuring my wisdom is passed along with my wealth. And that really is the center of everything that Lou and I do in our practice and our counseling philosophy. So one of the things that, I'm going to turn it over to Lou here in just 1 second, but we would really encourage many of our clients to start holding these family meetings, and it's something that we can do with you if you're uncomfortable doing it on your own. And a family meeting is really an opportunity for you to discuss with your loved ones what your plans are if you do become incapacitated or disabled, and what you want to happen with your assets when you're gone. So, Lou, I'm going to go ahead and pass it over to you.
Family meeting, in our opinion, should take place soon after you've created your plan, when the plan is fresh in your mind, when the suggestions that we may have planted with you are also fresh in your mind. And so who should attend a family meeting? Here's a list of some of the people. Particularly family members who are involved in your plan. So your spouse, your children, particularly your adult children. We don't necessarily suggest that your young children should be involved in that. The people that you've appointed in the various roles, trustees, guardians, personal representatives, agents, under your powers of attorney, people that are going to make your health care decisions. And then we also think it's very important that you bring other professionals to the table. So your financial advisors, your CPAs, because it's really a team effort, and many times your advisors know you as well as anybody. We have some great what we call referral partners who are financial advisors. They're just wonderful relationships with their clients, and they really make a great team member for family meetings. And in the event of your disability or death, these are going to be very important people that you're going to want your family members or your successors to turn to, know who they are, know how to reach them, things like that. So where can the family meeting take place? It can take place virtually anywhere. It can take place in our office. It can take place in your advisor's offices. It can take place in your home. We, in our new office, have a learning center that we're building out. We're going to be able to seat about 20 people, 18 people, and we're almost finished with the build-out of it. We have classroom-style desks like this. We have chairs almost like this. We're going to have the PowerPoint capability. And we'll be starting to have some of those meetings in our office. In fact, we've already scheduled a few. A few of our clients have asked if over the holidays when their children are in town, if we can start having those meetings. And for our clients who have created an estate plan, essentially our fee agreement says that the family meeting is part of what you're paying for. So we don't charge extra for those as part of the plan. And for the clients, most of like yourselves who are on the maintenance plan, that also is part of the plan that you're paying for, because we think the family meeting is just such an important part of the plan. There's going to be certain information that you're going to want to talk about in any family dynamics. You may have special, needs children, children with incapacities, children who have learning issues or behavioral issues. You may have difficult assets. What would we call difficult assets? Well, I happen to think oil and gas interests are difficult assets. They're assets that, you hold an interest in a lease in Wyoming or Oklahoma or Texas. They're very difficult to get retitled. They may produce a few $100s of income a year to the point that you think they're not worth the paper they're written on. But they're assets that tend to get passed on generation to generation. So what's the best way to handle them? What's the best way to title them? Timeshares, a very difficult asset anymore. A lot of people really want to get rid of their timeshares. And most of the time when we're dealing with administration, either in a probate or a trust administration, the family doesn't want them anymore. They're just expensive, and there's just so many other alternatives now. So that's a difficult asset. Just family issues in general, family dynamics, it would be the exception for us to tell you that we work with perfect families that have great dynamics and all the children get along and there isn't going to be problems. So these are the times to have those meetings to discuss. What we not talk about? Well, unless it's something that you want to talk about at a family meeting, we're not going to talk about your assets. So the purpose of the family meeting isn't for us to tell everybody in attendance what you own, how much it's worth. That's just, that's not an area we're going to go. Now, if you want to have a discussion that's specific about some assets, then certainly that's what we'll talk about. Whether it be, again, the special assets that are unusual, or you want to talk about how you want the assets distributed. But we're not going to put up on the wall of your net worth statement, or tell anybody in the room what your net worth is or anything like that. And so what's the benefit of the family meeting? I think in part, the benefit from our perspective is it introduces your extended family, your children who are going to have a role in your plan, your helpers, which we call your trustees, your agents under power of attorney, your guardians of minor children. It's going to introduce them to the team. That's why we think it's important for the team to be there, because then they know who your advisors are, and they know who they would need to reach out to in the event of any kind of emergencies. You can explain, and we help explain what you've done. Most of you, if you've experienced the estate planning process with me as opposed to Crystal, you're familiar with the charts I put up on the board with the old-fashioned overhead projector. And a lot of people, I think, like that because you can kind of see your plan in 3D. I call it the floor plan. And I think that that's helpful when we have the family meeting, that your children and helpers understand and they can see their role in that same process. So it's not, it's not so abstract to them. So that if you've appointed a child as a trustee, we need to tell the child what is a trustee, and the child needs to be able to ask questions of, when do I act, and how do I act, and what shouldn't I do, and who do I call, and things like that. We talk about disability. A lot of your plans have what we call a disability panel, and the panel is an approach to determining incapacity. If you're unable to act as a trustee, well, your panel is often going to be your children, or they could be the backup panel, but they need to know that they have that role. Many times, if you haven't had this discussion, your children aren't going to know that they have a role. And so if they don't know they have the role, they can't act as your panel member. So your plan isn't going to work unless the people that have a role in it understand what that role is and understand when it's time to act and what they need to do. The other thing would be to explain the order of appointees. Not every body is going to appoint in the role of helpers the oldest child or the child that lives the closest. You're going to choose the people that are the right choice for that job, whether if it's a trustee role, it tends to be more of a financial role. If it's a healthcare role, it's a different role completely. Obviously it's a person that understands in healthcare and how to make healthcare decisions and would follow your wishes. And so in order for your children to understand that, or if not children, other family members, it's a good idea to explain to them why they've made that decision. So a lot of people are worried about, well, what happens if I do such and such? It's going to hurt my child's feelings. Well, we don't think that your child's feelings are as important as, choosing them because if they're the wrong person, but we do think it's important that you explain why you're doing what you're doing. So you're able to pass on assets to your children in what we call lifetime protective trusts, which allow the assets to be held in a trust, and they're 100% protected from divorce because they're never really part of your child's estate. They're part of the trust that they've inherited. And you get to choose who the trustee of that trust would be. It can be the child, or it can be another person. It can be the child and a co-trustee. You have lots of options. But one benefit in Arizona is that you can choose the child as the trustee, and at the same time, the child still has creditor protection. So your child can get the best of both worlds. So a mature adult child can be trustee of his or her own share. So what happens if down the road you've created your plan and now something happens and you feel like there's a need to change it? Well, what can happen? We call that the hit parade. So all these different things that can happen to your child that they can get hit by. They can get hit by the bus, they can get hit by alcohol, they can win the lottery, they can do some good things and some bad things. And all of this can be reflected in the trust that you're creating for the child, because you can change that down the road. So what you've done today, you can change later, and you can explain this in the family meeting to your trustee, what your goals are, what your wishes are, why you've created the protective trust for your children. So again, a lot of this depends on the children's ages.
While these lifetime protected trusts can be very general and liberal in their distribution standards, which means if we go back one where the children are able to use the money that's in there for a down payment on a house or to start a business or invest in property or things like that, that's not always appropriate for each individual child, right? So when Lou and I are talking with our clients, we'd like to talk to them about what is appropriate for that particular beneficiary. So maybe you have a beneficiary that it's not appropriate to have them act as their own trustee. There are other ways to set up their plan, and maybe you don't want them or aren't comfortable with them having as free of access to the funds. Maybe there needs to be restrictions. Maybe there's a beneficiary who has had gambling issues or substance abuse issues, or maybe it really has a bad track record with marriages, right? So there are ways to make it a little bit more conservative in those distribution standards, but many of our clients feel that for their mature adult children, this is a way of setting up their plan that they feel very comfortable with.
Right. One thing you have to understand is that if you create a trust, no matter if it's liberal or conservative or requires drug testing or whatever you want to say, if you appoint the child beneficiary as the trustee, that's not going to matter because the trustee has full control. So you have to appoint somebody else as the trustee, or at a minimum you have to appoint a co-trustee if you want that level of control. So you really have to be careful when you're doing that. One thing I want to mention about the sprinkled provision, we get a lot of people who come in and they have sort of a predetermined idea that they'd like the trust to be distributed to the child at various ages. So a third of it at age 30, and then another chunk at age 35, and then the balance at age 40. And the problem with that approach is that whatever you distribute out of the trust is now losing the protection. So that idea in principle makes sense, make the child wait until they're older and then give it to them in pieces. But the better plan, in our opinion, is just make the child the trustee at that age. So if you say, we're going to have a trustee until the child's 30, then when the child's 30, let them become the trustee. But we're not going to terminate the trust. We want the trust to continue because the creditor and the divorce protection continues as long as the assets remain in the trust. Once it comes out, the protection's gone. So we generally are not doing these sprinkling trusts. You won't see those very often in our We touched upon this in some of our previous workshops, but IRAs are special assets because they're all taxable. So almost everything that you can distribute in your estate, real estate, money in the bank, investments, business interests, is not taxable, income taxable. Now, if you have an estate that's large enough, you could deal with an estate tax, but we're not talking about estate tax here. But income is taxes paid on every penny that comes out of an IRA. And then a couple of years ago, the Supreme Court held that inherited IRAs are not creditor protected generally. So it depends on the law of the state. But as a rule, the Supreme Court said that under federal bankruptcy law, that an inherited IRA isn't a creditor protected asset. Your own retirement plan is. So if you have a 401k or an IRA, it's creditor protected because you earned it. But if you have inherited it, it's not creditor protected unless the state your child lives in is going to creditor protect it. And in Arizona, we do have that creditor protection for an inherited IRA plan. So if your child lives in Arizona, inherits your plan, their inherited IRA is creditor protected. But if they live in 41 other states, they're not. Only 9 states presently creditor protect an IRA. The bottom line, though, is that if it's important that your child have a creditor protected IRA inheritance, then the alternative for the last couple of years has been to create a special trust called a retirement plan or an inherited IRA trust. And that IRA trust is intended to hold only the inherited IRA, generally nothing else. And that trust is created to allow the stretch out, which allows the beneficiary to take minimum distributions over their lifetime, as opposed to having to take everything out at one time, which is all taxable.
How many of you have really taken the time to write out those types of instructions when you're going to be gone for a lifetime? Okay. I'm going to venture to say many of us haven't. Right? A lot of us have good intentions to do those things and we don't. Again, that comes back to this whole family meeting and conversation concept. And so one thing that we like to think about is, who's going to serve as the guardians of our children? And chances are no one is ever going to act the same way that you would and raise your children exactly the way that you would, because they're not you. Right? So the best we can do is to find somebody who's going to follow our wishes as closely as we would do it if we were still around, right? That babysitter instructions. But if they don't know what they're supposed to do or what you would have done in that situation, what are the chances are that they're going to do those things? 0, right? So it's really important that you think about those things. And another thing that I like to talk to my own clients about is there anyone that you would never, ever, 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 ever want to serve as the guardian of your children, even temporarily, right? And if so, there's a document for that, right? We have a tool in our toolbox that we can help with that. And it's something that I've done in my own family, right? There are people who look really great on paper, but may not do things the way that we would want. And so what my husband and I have done is we have created this plan, this document, and we've listed out the reasons why we don't want these people to ever, ever, ever serve as guardians of our children. And we've just put it in the back pocket. And if those people ever try to take guardianship, if we don't come home from date night, right, then someone else, whoever our guardian is, can let the court or whoever know that there's some additional information that they need to make this decision, right? The court typically, when you name a guardian, is going to take that nomination that you have made and pretty much rubber stamp it for the most part. But they're always going to look at the best interest of the child. So if there's somebody else that looks good on paper that comes forward, maybe they have a lot of money and they look really good on paper, and the person you've named as the guardian doesn't have that and doesn't have the means, right? The court's going to look at those things. So having some extra paperwork in the back pocket is sometimes helpful. One of One of the things that we're able to do in our trust-based plan is to create a common trust, or what we call a pot trust, for the minor children. It's basically one bucket of money that's held for the benefit of all of those common trust beneficiaries, and it's held there and managed by whoever you choose to be the trustee. And the trustee can make distributions out of this common trust for as long as we have those beneficiaries. So that common trust typically terminates upon a certain milestone. Maybe the youngest child has reached a certain age, or they've graduated from college, or something like that. But that milestone is something that the clients have to decide during our counseling meetings. And certain distributions can be treated as advancements if the client wants that. So if there is, let's say, an older child that's part of that common trust, and they want to go on to graduate school. Well, if you were around, maybe you would help with graduate school. Maybe you wouldn't, but does your trustee know that? And if you would like them to pay for graduate school, do you want that to be treated as an advancement against their ultimate share? Because that's going to, lessen the amount that everybody else gets. So those are things to think about. And some of the things that we talk, that worksheet include are things like pre-college education. What type of schooling would you prefer for your children? Public schools, is that fine? What about religious schools, parochial schools, private or charter? Do you have a preference? Do you want them to go someplace in particular? Do you want them to stay in the state of Arizona? Do you care if your guardian lives in another state? I mean, those are all things to think about. What about extracurricular activities? Were you a Girl Scout or a Boy Scout? Is it really important that your kids are involved in those things? What about special field trips or band or sports? Are there things that you want them to have the opportunity to be involved in? Are there things that you don't want them to be involved in? What about college education? How much are you willing to pay towards college education from this common trust? Because again, this is one pot of money for all of the kids. And so what if one child wants to go to a private school that costs $70,000 a year? That's going to eat away a lot of the money that's left for those younger beneficiaries. So do you want your trustee to do that? Should your children that are going to college have to work and pay part of their own way? What about a qualifying grade requirement? What if they just are going to college and just being a career student and partying all the time? Do you want to continue for schooling like that? Should you have some sort of requirement? What about study abroad or other things that you would want to provide? What about an incentive to graduate in 4 years or less? Help for guardians. This is a question that just recently came up with some clients that I was working with. They have an individual who is ideal as a guardian, but is a single person and works full time. She's a career woman. But if something happens to them, that's who they want their kids to go to. Is she going to have to give up her career to take care of these 4 young children? And if she does, how is that going to affect her ability to actually take care of herself, right? To pay for her own needs. The trust can take care of the children's needs, but should there be some sort of compensation for the guardian? What about vacations for the guardian? Should they get some respite care of their own? We kind of hear about respite care if we're taking care of our family and things like that, but should that guardian get the same type of thing? Visitation with other loved ones. So what about trips to see other family members elsewhere? So those are considerations as well. So how important is it to you that that happens? What kind of communication would you want for your children to continue having with those people? As grandparents, you probably would want to continue being involved in your grandchildren's lives, is my guess too. So maybe you should have those conversations with your kids also. What about religious preference? Some people go to church every Sunday. Some go multiple times a week. Some go every single day. I know a lot of Catholics who still do that. What if it's okay? What if you only go on holidays? What if you don't go at all? There's whatever our clients decide to do or they feel for themselves is perfectly fine with us. Lou and I don't have any judgment on anything like that. But make sure your loved ones know what your intentions are for those types of things. But maybe you don't want your children getting a driver's license until they're a little bit older. Maybe you don't want them driving other things. Maybe you want them to have a certain kind of car. What about firearms? Arizona is a huge, huge firearms state. And what if the guardian has firearms in their home and you're totally against firearms? Is that a problem? Should that be discussed ahead of time? Lou was talking with you guys about the lifetime protected trusts and how the beneficiaries can serve as their own trustee here in Arizona. What if a beneficiary receives all of that money and is now their own trustee, and your intention is to have it left in that trust so that they have that creditor protection? What if they don't know what they're supposed to do? What if they don't have any basic financial skills? It might not even have been beneficial at all. Maybe it should have just been left outright at that point, because that's all they were going to do, is just take the money and run, right?
I think one of the talking points at a family meeting, going back to the Lifetime Protective Trust, is to have the discussion with the children who are going to be the beneficiaries of those trusts and explain right up front. I'd start planting that seed immediately, that you're going to inherit in a trust, and here's why we're doing it, and here's how it's going to work. And if you're the trustee, then explain that, and if you're not the trustee, explain that. Because really, in a sense, that trust is going to work or not work because of your beneficiary's understanding of it. And recognition that this isn't because mom or dad don't trust me. It's because they don't trust the rest of the world. And they want to protect me from all that risk. And I would have that discussion from the get-go, and I would keep having that discussion.
Other very special beneficiaries that we often are coming across, even more and more now in our plans, are special needs beneficiaries. And these are individuals who maybe have Down syndrome or autism or some other sort of disability, and they're unable to take care of themselves. And so, are there certain benefits that special needs beneficiary is receiving, which are needs-based programs? If there are, we need to know about them when we do planning so that we can make sure the plan is correct for that beneficiary. But whoever you leave as a trustee also needs to know what those benefits are. Also sharing what type of disability the beneficiary actually has and how it affects them on a day-to-day basis. Some beneficiaries might be in what I think of as a gray area. They may not be able to truly handle their own financial affairs, but they're out there and able to hold down a job and drive a car and do a number of other things. That type of special needs beneficiary is different than a person who absolutely can never do those things. So what does the daily routine look like for those people? What types of activities does the beneficiary like to engage in? What makes life easier for them? Sharing those babysitter instructions is very, very important, because oftentimes those people will have difficulty expressing what they need, and it makes it even harder for those guardians or trustees to know what it is if you don't leave those instructions. Pets, or fur babies I call them, right? Your four-legged children. Are they microchipped? Are you leaving them to anybody in particular? Did you name somebody in your plan? Did you set up some sort of a pet trust for them? And if you don't know what those are, we'd be happy to talk about them some other time. We're not going to get into that tonight. But same kind of things with other beneficiaries. Are there dietary restrictions? Are there other routines or things that need to be taken into account?
So much of estate plan has focused historically on taxes. Create plans that avoid taxes, and whether estate or income or whatever. And really not enough time is spent on focusing on the things that we own that, on death are going to be passed on to other people. What's important? What's not important? Who should have special items? Again, if you're our clients, whether it's a will or a trust, we have a memorandum. And in that memorandum, you can fill it in and you can say who gets what. I really think it's important to not only, create your list and avoid the complete destruction of the family unit when they start fighting over stuff, but also to tell stories, not only verbally at a family meeting or otherwise, but put it in writing. A lot of people anymore like to blog. They write on Facebook and Twitter. Well, write stories about experiences and where things came from, and pass the stories along. Oil and gas interests. One thing that we're starting to look at as an option, because one of the problems with oil and gas interests is if you own it and you die and the next generation owns it, they have to retitle it. And then every time down the road. Because these oil and gas interests could last forever. So an alternative, instead of either holding it in your name or putting it in your trust, which is what a lot of people are going to do at our recommendation, is you create a limited liability company now, have the oil and gas interest retitled into the name of the limited liability company, and you go through the effort to do that retitling one time, and then instead of having to pass the oil and gas interest generationally, you pass the limited liability company generationally. So there's only one retitling done, and you do it now. Then your children inherit the LLC, and they can pass on the LLC, or they can gift the LLC, and it's avoiding this problem that these oil and gas interests, because it's expensive to retitle them every time, and sometimes it's more expensive than the annual income. When again, with the timeshares, do you want the trustee to keep them? A lot of times it's not what you want, it's what the people who are inheriting want. So I would suggest sometimes looking to see if you can gift them now, if you can sell them on the resale market now, or your trustee or your personal representative in probate oftentimes can negotiate to turn them back over to the administrator. So there's some options there. If you own real estate in other states, the trust is a great plan because we want to make sure that your real estate gets retitled into your trust so that it's not subject to probate in the other state because the trust owns it instead of you. So part of our planning philosophy is always to make sure that real estate gets retitled as part of your trust planning. And business interests. Now businesses can be a real challenge when you've got, it's a major part of one's estate. I just strongly urge you to get it done because I know you don't think it's going to be a problem with your family. Your kids are special, they're not going to fight. Those are famous last words. It really does cause a problem. The other thing I would suggest would be with the digital technology that we have is take pictures. So you create your list, but also take pictures because if you just put, Barbara, what's that necklace you're wearing? What would you call that?
Lois's necklace.
Lois's necklace, okay. So I would suggest in your making your list, I would say who gets it, but then I would take a picture of it.
And a story behind it.
And a story behind it,
It's all
exactly.
in there, yes.
Exactly. No, wills historically have allowed, in Arizona and most states, you can create a separate list, even if you had a will-based plan instead of a trust-based plan, so that you don't need to state in the will who gets stuff. You can refer to a separate list. So it's not a codicil, it's really, an addition to the will. And we can do the same in your trust. So instead of listing in your trust document who gets what items, we refer to a separate memorandum. And the memorandum is where you're listing it. And you always include a living will, which is your basic statement that if I'm in a permanent vegetative state, or I have an incurable illness, I don't want my life artificially prolonged. And generally it'll state, I don't want mechanical resuscitation, I don't want dialysis, I don't want things that are keeping me alive. The problem with it is that it's so black and white. And nothing in life is as black and white as, that a doctor's going to say exactly, this is the moment, or your family's going to know that this is the moment. So one thing that we recommend, not only in a family meeting, but in writing, is you be very specific in terms of at what point you wouldn't want to have care that would keep you alive. So there's a lot of different forms that you can use for that. Here's one that asks questions such as, if you can no longer recognize or interact with your family or friends, would you want treatment or would you definitely not want treatment? If you can no longer think or talk clearly, do you want treatment or definitely not want treatment? If you can no longer respond to commands or requests, if you can only get around in a wheelchair, if you could only spend time at home and you could never go anywhere, if you are in untreatable pain, all of these are asking you to give input on would I want my life prolonged, what type of treatment would I want. We really recommend that you go through the exercise of answering questions like this and having that as a topic at your family meeting.
We intend for the worksheet, or the extra goodie worksheet that we put into the binder, to really be that conversation starter. It's definitely not an exhaustive questionnaire about what you would want in every particular situation that you might come across. And like Lou said, you probably have already had those conversations with your spouse, if you have a spouse, or if you haven't, you probably do know what the other person wants. But it's the kids, or who's going to be making the decisions afterwards, that don't have that information.
It may be difficult for you to imagine this conversation. You may feel like my children don't want to hear it, or I don't even know how I'm going to raise it. So one of the suggestions is to start with the story of someone else. So do you remember so-and-so across the street when she passed away and how difficult it was? And, well, then you could say, I want to have that discussion so you know what I want. And if your children are still reluctant, then say, well, Ms. Patton, my lawyer, said I have to have that discussion. We just want you to be very clear on what your end of life wishes would be. No, historically it's been end of life. We're getting a little bit as we go into as we advance as a species, to where we're getting more and more options. So if you live in Oregon, you can choose to end your life. And I think that maybe, somebody told me New Mexico is now allowing that to happen. So no, 10 years ago we wouldn't be having this discussion. And now you can take a pill and you made the decision on your own. But you certainly need to be having the discussions, because if somebody has to make those decisions for you, you want them to know what your decision would be, because that's all they're doing. They're really trying to honor your own wishes. Your healthcare power of attorney is naming an agent to speak for you, and legally they stand in your shoes. So even though they may be speaking contrary to your wishes, the doctor has to listen to them because they have the legal authority.
In Arizona, one thing that's very, very clear is that a living will is not a do not resuscitate word. That is something that is completely different in the state of Arizona. And a lot of times I have clients ask me, or tell us, am I going to sign a DNR today? And so a DNR is really a separate document in Arizona. It must be printed on orange background, either letter size or wallet size, but it has to be orange. It has to be witnessed and signed by your healthcare provider, that they have discussed with you what the ramifications are of that DNR. And really what it covers are really cardiac events. If you have a heart attack and you have a DNR posted, they're not supposed to try to do anything, even in the hospital, Greg. But sometimes they do, right? But the living will is not the same. If you were on your way home from our office and you had your big red binder in your front seat and it had your living will in it, and you were in a car accident and they found your living will, they're still going to try to do everything to save you. It's not a DNR. It's a completely separate document, and we do get that.
It's a challenge where you have very specific wishes, and the medical community is sort of trained otherwise. So that's why it's so important that your instructions be really clear of what you would want. So the memorial instructions, we've also, in your binders, we include a section on memorial instructions. We also include in your binder a document that we call your personal wishes letter. And that's about a 30-page or so document. No, I think it's more like 50 pages. And it's just full of information that you complete on everything from what you own, who you owe, where you have assets stored away, where you have assets hidden. There's I don't know how many people are in here tonight, 60, 70 people, or 70 people. This is a small percentage of the people that are out there. We don't represent everybody. Not everybody in the valley is our client. But what we want is the people who we do represent and the people who are here tonight to understand that, some of these things that are stated here, that estate planning isn't just putting a document together and saying, oh good, now I know who's going to inherit my fortune. It's really this whole process. It's storytelling, it's getting it on paper, it's having the family meeting, and it's all you know, it's all a big, you know, process that we want to help you with. And so we feel very fortunate that those of you who we have represented, we really appreciate it. And we appreciate you as our clients. So thanks a lot.